you were having a problem.
Well, Judge Middleton, I am working now. I'm at Ox Paper Mill.
All right, well, let me slow down for a minute and say call the case. This is file 23130LT. It's entitled Hatfield Investments LLC versus Wanda Lewis. Attorney Jessica Brandow is here, and she's been here on multiple hearings in this matter. Also standing by is Meg Bauer from Legal Aid. This case has quite a lot of history. On March 24th, we were here the first time. The defendant's arrearage was substantial. She owed $5,200 through April. Rent was $800 a month. And then, through March, we added April's rent, which made it $6,000 plus court costs. $64.24 is what it would have cost through April. So she indicated that Keystone was going to help pay part of it. She had a new job at Ox Paperboard. So we continued the matter until March 31st. We made the same finding we did on March 31st, that the amount of rent was $6,000. There was $175 of late fees, and Keystone was going to pay a portion of it. That did not happen. The rent was not paid. Plaintiff requested a writ of eviction, and that is sitting here. It was filed April 13th, so now it's April 28th. 15 more days have passed because I was on vacation. You wrote me a long letter that I had a lot of trouble reading, but the bottom line is you haven't paid the rent and they still want you to move, and they've asked me to file a writ of eviction. Ms. Brandow, anything you wish to add? Were you able to read her letter?
I did read what I could understand of it, Your Honor. I have spoken to my client as well, and just here to see, how we can proceed and how we can help Miss Wanda with her concerns.
All right. Well, she keeps saying he won't talk to me, but he doesn't have to talk to her. He was doing this through you. I would put the three of you in a breakout room, but somebody's in the breakout room. So is your client willing to work with Miss Lewis?
Only to a certain extent, Your Honor. This is the arrearages here, like you said, are substantial. I don't see how she is going to be able to get caught up anytime soon, especially with the additional rent being added. Additionally, there are some electric bills that are unpaid that my client is having to deal with.
No, those are paid. It's paid.
So
that
my client, okay.
All right, don't, we'll let you speak.
Okay, sorry.
So
all right, well,
at this,
do you have $6,500 laying under your mattress?
No, but as I stated, I tried to call Mr. Hatfield and the attorney several times, but no one's answered me. And I was trying to call him to tell him that I do make a decent amount.
All right. Okay. Well, we understand that. The problem is he doesn't want to work with you for the next 10 months to get his rent caught up.
It would take me approximately, because I had told Mr. Hatfield when I got my taxes, I would pay everything up. Unfortunately, my taxes were messed up, and so I had to do an amendment, and my taxes at that time was $10,542. So I had no problem paying everything up until I started working. But however, I have no problem with at least paying Mr. Hatfield $1,000 a week. And I still told him when taxes when they do come, I would also pay him extra months of rent when it comes. But unfortunately, I had to go to the IRS to identify and have them amended as well, because the person that did them really screws them up. So I had to go to H&R Block and have H&R Block amend them. And they are I have a few more weeks before they come. But I have no problem with at least paying Mr. Hatfield $1,000 a week and catch it up, and after that, pay him.
Well, 1,000 a week is a substantial payment. They
Well,
don't have to, they have 56 days to ask for the writ of eviction, and then they have an additional 56 days before they serve it. So that gives them quite a bit of wiggle room. They have requested a writ of eviction, but I have not signed it. Ms. Brandow, what's your thoughts after having heard what Ms. Lewis said?
Your Honor, I would have to check with my client as far as whether he is willing to rely on Ms. Wanda's representation on what she can pay per week. I would have to check with him on that, because I know that he has tried to work with her in the past and has not been given the money that Ms. Wanda has indicated that.
Are you in the house now, Ms. Lewis?
Yes, Judge.
Well, it looked like it was a mess. It looked like it was all in terrible disarray.
My house?
Yes.
Oh, no, this is the porch. There's nothing dirty about the porch. It's just kids' toys. I keep this house anytime anybody ever comes here.
When you were in the garage or something, is maybe when
No,
all
this
the
is
crash
the porch.
and banging was going on.
I don't have a garage. This is the porch. And there's nothing, it is nowhere near dirty, a mess at all.
Well,
I don't live
to some extent, when we have the hearing, we had 2 hearings.
Yes.
And then I made a ruling, and then you wanted to talk to him, and he's like, I don't want to talk to her anymore. I had 2 court hearings, pay the money or move. So you wrote this long letter, and I set this hearing, and Ms. Brandow did talk to Mr. Hatfield, but you're gonna be more than $7,000 behind on your rent. And,
yes, and that would take me
and
about
in May's rent. You said Keystone was gonna pay some. What happened to that?
Well, Keystone sent a letter stating that what they were going to pay. They didn't tell me that I had to pay the rest before, so I had called like 211 to help out, but they nowhere had any funding. So after I couldn't come up with the other amount that was on the letter, then Keystone said that once I start paying on it, then they can help with and it was $1,000. But once I start paying on it, then they could pay that, because that's all they paid up to was $1,000.
How are you gonna afford $1,000 a week?
Judge Middleton, I gross over $2,200 a week.
All right, well, you're doing pretty good then. So having heard all that, Miss Brandow, what's your thoughts?
I would think that my client would want to see proof of Miss Lewis's employment and proof of what she is making before he would make a decision on that. He may be willing to work with her, but again, we would need some paperwork to show, because so far he has not received.
Do you want me to enter the writ of eviction, or are you willing to have me reset this?
I think our preference would be to have the writ of eviction available, Your Honor. But if we need to reset it, we could work with that as well.
Well, I could enter the writ. You're entitled to it, but if she's gonna do this, I agree. Now, one of the problems is once you file the action, then you get in trouble if you accept partial payment. But I will allow the defendant to make any payment without precluding the plaintiff's ability to proceed. This isn't a termination of tenancy, it's a non-payment of rent case.
This court hearing focuses on a landlord-tenant dispute between Hatfield Investments LLC and a tenant named Wanda Lewis. The case involves unpaid rent and a potential eviction. The hearing is presided over by Judge James Middleton and the landlord. It is represented by attorney Jessica Brandow. A representative from Legal Aid, Meg Bauer, is also present. At the beginning of the hearing, Judge Middleton calls the case and explains that the matter has a long and complicated history. The case first came before the court on March 24th. At that time, Wanda Lewis owed $5,200 in unpaid rent. and the monthly rent for the property was $800. When April's rent was added, the total amount owed increased to around $6,000, not including court costs and late fees. During that earlier hearing, Lewis explained that she was experiencing financial difficulties, but had recently secured a new job at Ox Paperboard, which would allow her to start paying off the rent. She also said that an assistance program called Keystone was expected to help cover part of the overdue rent. Because of these promises, the judge allowed the case to be continued, giving Lewis more time to resolve the issue. The case returned to court on March 31st, but the rent was still unpaid. The landlord's attorney again explained that the amount owed remained around $6,000 plus late fees. Lewis repeated that she was expecting help from Keystone and that she had a job lined up, so the judge gave her additional time. However, things did not improve. The judge explains that no payment was made, and the landlord eventually requested a writ of eviction, which is a legal order allowing the tenant to be removed from the property. That request was filed on April 13th, and now the court is meeting again on April 28th to determine what should happen next. The judge also mentions that Lewis sent him a long handwritten letter explaining her situation. Although he had difficulty reading parts of it, the main point was clear. Lewis had not paid the rent, and the landlord still wanted her to move out. Attorney Jessica Brandau tells the judge that her client, the landlord, has already tried to work with Lewis multiple times. However, the amount of unpaid rent is now very large, and the landlord is concerned that Lewis will not be able to catch up, especially since the monthly rent continues to increase the total balance. Lewis then speaks and explains her situation. She says she tried to contact both the landlord and the attorney several times, but did not receive responses. She explains that she recently started working and claims she now earns over $2,200 per week. Because of this new income, she believes she can start paying back the rent. Lewis proposes a payment plan. She tells the court that she is willing to pay $1,000 per week to the landlord until the debt is paid off. She also explains that she is expecting a tax refund of around $10,542, which she initially planned to use to pay the rent in full. However, she says there was a problem with her tax return, and it had to be amended through H&R Block. Because of that mistake, she is still waiting for the refund to arrive. Lewis also says she contacted Community Assistance Services, including calling 211, but was unable to find additional funding. She explains that Keystone would only contribute about $1,000, and they required her to first make some payments on the rent before they could provide that assistance. The judge questions her about how she plans to afford paying $1,000 per week. Lewis insists that her new job provides enough income for her to do so. However, the landlord's attorney remains skeptical. Brandau says that before the landlord would consider accepting such an arrangement, he would want to see proof of employment and documentation of Lewis's income. Another issue arises during the hearing regarding the condition of the property. The judge mentions that the home appeared messy during a previous inspection or hearing. Lewis responds by saying that what the judge saw was simply children's toys on the porch, not a dirty or poorly maintained home. She insists that she keeps the house clean and that the judge may have misunderstood the situation. Despite Lewis's explanations, the judge expresses concern about her past promises. He points out that during the earlier hearing in March, she told the court she had already started the job at Ox Paperboard and would begin earning money soon. Now, more than a month later, she is saying nearly the same thing again, that she is still about to start work. Lewis responds by explaining that there was confusion between two different paper mills. She originally expected to start work at one location in White Pigeon, but that opportunity did not work out. She says she has now completed orientation, drug testing, and other requirements for a job at a different location in Constantine, and she is scheduled to officially start working the following Monday. The judge says that because of these repeated delays and unfulfilled promises, the landlord has lost trust in Lewis's statements. From the landlord's perspective, several months have passed without receiving any rent payments. While legal costs and unpaid rent continue to grow, the judge also points out that the landlord is paying legal fees every time the attorney appears in court, while Lewis does not have to pay for representation. Meanwhile, the unpaid rent keeps increasing by another $800 each month, which further harms the landlord financially. At this stage, the landlord's attorney says her client would prefer to have the writ of eviction available, but they may be willing to allow more time if Lewis can provide proof of her job and start making payments. The judge explains that, legally, the landlord is entitled to the eviction order, but he decides to give Lewis one final opportunity. Instead of immediately signing the writ of eviction, he continues the case for another 10 days to see whether the landlord is willing to work out a payment arrangement. However, the judge warns Lewis that if the situation does not improve quickly, he will likely approve the eviction. He tells her that she must either pay a significant amount of rent or prepare to move out. The judge emphasizes that the landlord is not required to accept a payment plan. While Lewis wants an arrangement that would allow her to stay in the property and gradually repay the debt, the landlord has the legal right to refuse and simply proceed with eviction. The hearing ends with the judge scheduling the next court date for May 15th at 1:15 p.m. At that time, the court will review whether Lewis has provided proof of employment and whether any payments have been made. Before the hearing concludes, the landlord's attorney informs the court that she is expecting a baby on May 19th and may need another attorney to appear if necessary. The judge wishes her good luck. Finally, the judge again advises Lewis that she should come to the next hearing prepared to show good faith, which means bringing proof of employment and possibly making a large payment toward the rent. Otherwise, the landlord will likely request the eviction order, as she could be forced to leave the property. The hearing ends with the judge emphasizing the central issue of the case. Either the rent must be paid or the tenant must move out.